This is Gao Yu. I'm from Linda Liu and Partners. Today, I would like to share with you a topic on the recent draft amendment of Trademark Law of China. There was a draft amendment of Trademark Law of China published in this January, seeking public opinion. The amendment is an overhaul of China's trademark system and has attracted wide attention and discussion from outside. I summarize some of the highlights of this draft amendment as follows. Point 1. Strengthen the use requirement. In the current trademark law, the use requirement is mainly reflected in the non-use cancellation procedure. In this draft amendment, the trademark applicant will be required to submit trademark use statement or undertaking to use the trademark in the application. After registration, the registrant will be required to submit a statement on the use of the trademark or justify grounds of non-use of the registered trademark within 12 months of every 5 years after registration of the trademark. This will encourage trademark applicants or registrant to use the trademark and decrease the number of trademarks that are filed not for use purpose. Point 2. Prohibit refiling of a registered trademark. In the current trademark law, trademark registrant is allowed to refile a same registered trademark on identical goods or services. Therefore, even if a registered trademark is not used for 3 consecutive years, the registrant may refile a new application for the same trademark on identical goods or services to extend its period in defining non-use cancellations or stall the time for another party to register conflicting trademarks. However, in this amendment, refiling of registration application for the same trademark on identical goods or services is generally not allowed. This will help discourage trademark registrant from repeatedly refiling trademark applications for the same trademark. Point 3. Transfer of disputed trademark in validation procedure. In the amendment for a disputed trademark which is against relative grounds of trademark law, the applicant of the invalidation may request the CNIPA to have the disputed trademark transferred to it. This will save time and efforts and avoid uncertainties for the applicant of the invalidation in separately prosecuting a trademark application to registration. Point 4. Simplify the opposition procedure and shorten the opposition period. In the current trademark law, there is a 3-month period for a third party to file opposition against a published trademark. After a trademark is disapproved in the opposition, the applicant of the opposed mark is allowed to file review on the disapproval decision. However, according to the amendment, the opposition review procedure is now deleted and the applicant shall appeal with the court if finds the decision unsatisfactory. The opponent, on the contrary, may still file invalidation if the opposed mark is approved and registered. This change increases the efficiency of trademark opposition and increases the cost and burden for the trademark Scottists. Point 5. Clarify scope of bad faith application and availability for damage claim against trademark squatting in civil litigation. Though there is a detailed rule about bad faith application in the Trademark Examination and Adjudication Guideline published by CNIPA, the draft amendment for the first time clarifies the scope of bad faith application. In the meantime, the amendment also clarifies the availability to claim damages against trademark squatting in civil litigation. This will help frighten trademark squatters and increase their responsibility for bad faith trademark squatting. These are some of the major highlights in the draft amendment of Trademark Law of China, which has been published to seek public opinion. The draft amendment has not been approved, and some further changes may come out later. There is no implementing rule regarding the amendment. However, we believe they could at least show the legislators' determination and direction on strengthening use requirement of registered trademarks, simplifying procedures in solving trademark disputes, and cracking down on bad faith trademark applications. We will surely keep you informed of any development in this topic. Thank you for listening. If you have any questions or any interest in this topic, please feel free to contact us via our email address, trademark@lindapatent.com.